Hi everybody, welcome back to the BizTech Academy. Steve here, and today I'm going to look at something different to what I normally do. And I'm going to focus on some new legislation that's going to be introduced from September the 4th. And more than that, this is Russian legislation. This legislation may impact shareholders of foreign PLCs or foreign public listed companies that have the bulk of their operations or their business in Russia. As an example, I would use Evraz, and the reason I use Evraz is because I'm a shareholder in Evraz, and personally, I'm potentially impacted by this legislation. Moreover, there's a great deal of speculation on social media that this new legislation entitled N470-FZ, catchy right, could give the Russian government the rights to appropriate the shares of foreign shareholders in these PLCs. Now, hopefully this video will shed some light on this because I'm going to review this legislation and try and pull out the pertinent points that apply or potentially apply to foreign shareholders. I do want to add a couple of caveats, however, before I go into the detail. And the first one being that although I mentioned Evraz as a company in this video a number of times, this particular legislation is not specific to Evraz. It relates to any potential foreign company that has the bulk of its operations or its business in Russia, and therefore any shareholders in that foreign company could be affected. Secondly, I also want to state that this is a review of Russian legislation, so it's not going to be the most gripping of videos. It's not going to be a Mr. Beast video, I can assure you. So for that reason, I do suggest that if you're not a shareholder, by all means watch it, but it may not be relevant to you. But if you are a shareholder in a foreign company, for example, Evraz, then I think it's worthwhile watching, and it may shed some light on maybe the concerns you have about this legislation and how it affects your shareholding. Okay, one final thing before I start, and as always, I must state that none of this is financial advice. I'm not a financial advisor, and everything I say today is purely my opinion based on my own interpretation of this legislation. I'd also add that I'm going to review an English version that's been translated from the Russian original by Google Translate. So again, there could be some nuances there that are not quite right through the translation, although to be honest with you, it does read relatively fluently, so I'd hope to think that it's generally quite good. Okay, the new legislation, as I mentioned before, has a very catchy title of N470-FZ, and it's made up of 13 different articles. I'm going to go through all of these articles to some extent in detail, but I will skip over many parts that are relevant only to Russian citizens or residents and pull out and go into detail the main parts that relate to foreign shareholders. Article 1 is a short section, and it basically covers and explains the intent of the legislation, and it's broken into two parts. The first section, which covers the bulk of the legislation, simply states that the legislation's intent is to protect the rights and the interests of Russian companies and Russian citizens by controlling how much influence foreign companies have on Russian business. However, the second section in Article 1 is more relevant to foreign companies and foreign shareholders, and it states, restrictive exemptions established by this federal law are not aimed at unjustified infringement of the rights and legitimate interests of foreign holding companies, their participants, shareholders, and other persons. I interpret this as saying that the main purpose of the legislation is to protect the rights and the interests of Russian companies and Russian citizens, but at the same time, there is no intent to bring any harm to foreign companies or foreign shareholders or others associated with foreign companies. Now, this is interesting because this is stated right at the start, and it sets the scene for what the intent of the legislation is, and it certainly says very clearly that there is no intent to harm foreign companies or foreign shareholders. Article 2 brings in the concept of economically significant organizations, or ESOs as I will refer to them from now on, and it basically states that the meaning of an ESO is a company that ensures the economic sovereignty and economic security of the Russian Federation. Now, of course, this is quite vague, but the article goes on and has 4 separate sections, and 2 of those have multiple segments in the attempt to try and define what an ESO is. I won't go into a great deal of detail in these sections, but the first section covers the size of the company, both in terms of revenue, employee, tax paid, number of assets, and etc. The second section has 5 subsections, and that covers the meaning of what it is to be an interest into Russia or to be important to Russian security. The third section talks about the ownership structure in the particular company itself, and basically qualifies in this particular section an ESO as a company where the controlling decision-making power is with the foreign company or the foreign shareholders. And the final section in this particular article states that the decision of whether a company is an ESO or not lies with the government through advice it receives from federal bodies. Note that there is also a final statement that says when the government has classified a company as an ESO, that particular ruling cannot be appealed. Now, as mentioned before, I'm using Evraz as the example as we go through this legislation, and I don't know in any which way whether Evraz will be classed as an ESO. But of course, for the purpose of this discussion, I'm going to assume that it is. If it wasn't, then this whole discussion is academic. If we move on to Article 3 now, Article 3 goes through the definition of what's called a foreign holding company, or an FHC as I'll term it from now on. An FHC is defined as any company that owns at least 50% of what has been deemed an ESO. So basically, if Evraz, for example, was deemed an ESO and it was seen that 50% of the ownership of the company was owned by the foreign holding company, in this case Evraz PLC, then Evraz PLC will be classed as an FHC. Now, for the purpose of this video, I'm going to assume that Evraz is an FHC. Of course, if it's not and it wasn't deemed an FHC, then the legislation wouldn't apply and this whole discussion would be academic. Moving on to Article 4, this has 3 sections, and this is the first section where the suspension of corporate rights is discussed. In essence, this article states that if an FHC, after the date of the 24th of February 2022, which as you'll all know was the start of let's call it the special operation, if that FHC acts in such a way that hinders the day-to-day operations or the decision-making of the ESO, then it shall have its corporate rights suspended. Again, and in relation to Evraz, if we assume that Evraz Russia will be classed as an ESO and Evraz PLC will be classed as an FHC, then I think it's fair to assume that corporate rights would be suspended in Evraz PLC. And the reason I say that is even though Evraz PLC has no intention to disrupt or put any harm to Evraz Russia, the UK sanctions that have been imposed on Evraz PLC have restricted what Evraz PLC can do, and therefore I think corporate rights would be suspended. Article 5 is really a process section, and it defines who can file an application for corporate rights to be suspended, and also note that the decision around corporate rights being suspended is with the arbitration court of the Moscow region. In summary, the parties that can apply to have their corporate rights suspended of an FHC through the arbitration court are the Russian government, any shareholder in an ESO, any executive or board member in the ESO, and anybody who has indirect or direct rights in the FHC. So basically a lot of people. The rest of Article 5, which I'm not going to go through, details the process for making the application for suspension of corporate rights and also the documentation and the decision-making process associated with that. So in summary so far, I can say that the legislation defines what an ESO is, defines what an FHC is, explains what the suspension of corporate rights means and when it applies, and also explains the process of how that happens and what is needed to make that happen. There's no denying it, it's a riveting read. Okay, moving on to Article 6, and I do promise you that it does get more interesting. Article 6 explains and defines what happens when the suspension of corporate rights occurs, and therefore what the FHC then is unable to do. In summary, there are 4 generic things that the FHC is suspended from doing, and these are as follows. Firstly, the FHC cannot call, attend, or vote in a general meeting associated with the ESO. Secondly, the FHC cannot sell shares in the ESO. Thirdly, the FHC cannot receive dividends from the ESO. And finally, the FHC has no preemptive rights to early purchase of shares that the ESO may issue. The article goes on and states that Russian residents and Russian citizens that have shares in the FHC must convert them into direct shares in the ESO. Article 6 goes on to say that the arbitration court can also make exceptions to these corporate rights suspensions, providing that if the exception is applied, the smooth running of the ESO is not hindered. Article 6 then goes on to talk about the process, how Russian citizens and Russian residents convert their shares in the FHC to direct shares in the EHO, but I'm not going to go through that into detail. But it is worth noting that at the end of the section, the Article 6 does state the following, which is very important. Features of the implementation by a foreign holding company of its corporate rights in relation to an economically significant organization provided for by this article are established for a period determined by a judicial act of an arbitration court, but no more than the 31st of December 2024 inclusive. To me, this states that the period of suspension of corporate rights is down to the arbitration court, but whatever they decide, it can be no longer than the end of December 2024. Now, of course, the Russian government could extend this deadline whenever they want to. They can simply change the legislation. However, what I see from this, and I think is important, is that the intent behind this legislation is that any suspension of corporate rights is temporary and not a permanent termination of those rights. If we move on to Article 7, then the start of Article 7 just confirms that any Russian citizen or Russian resident who holds shares in a foreign holding company must convert those shares to direct holdings in the ESO. It then goes on to define what indirect ownership is. So therefore, it's not just the fact that you own shares directly in the FHC. If you hold them through a fund or something like that, that will be classed as indirect ownership. And those shares also would need to be converted into shares, direct shares in the ESO. But again, and just so I'm clear, this only relates to Russian citizens and Russian residents. Finally, the section goes on and talks about when the conversion of shares into direct ownership of an ESO could fail, for example, when the incorrect documentation is used or when the inappropriate person signs for that particular conversion. All this is hardly relevant to foreign shareholders like me and you. However, the last section is very important, and it states the following. A foreign holding company at any time during the period of suspension of the exercise of rights has the rights to apply to an economically significant organisation with a claim for payment in the amount of the market value of the shares of an economically organisation that were not distributed among persons who entered into direct ownership of corresponding shares. Now, the Google translation of this particular section makes it a little bit difficult to read, but what I think it's saying here is that the FHC at any time can apply to the ESO for compensation for any shares that it is given to the ESO for the transfer into direct ownership of the ESO that have not been transferred so due to procedural impropriety. But why is this important? Well, this is important because I think this reinforces that the legislation is not there to intend any harm to foreign companies or foreign shareholders. It's basically saying that the foreign company, the FHC, has the right to claim back compensation for any shares that is given to the ESO that are not distributed to shareholders within the ESO itself. And Article 8 gets even more interesting. The article starts by talking about situations and occurrences where the suspension of corporate rights can be lifted. Sorting the wheat from the chaff, the section basically states that corporate rights suspensions can be lifted, one, at the end of the war, and secondly, if the arbitration court deems that the suspension of the rights would no longer have any effect on the smooth running of the company. This is great because it implies, again, to me at least, that the Russian government see this legislation as temporary, and at some stage in the future, they expect some form of normality to return. Moreover, the final section of Article 8 states that if at the time of suspension being lifted, the ESO does hold shares that have not been distributed to direct shareholders, then the FHH has the right to have those shares returned to them. This is different to the above because instead of getting compensation when the suspension is lifted, the FSH has the rights to receive the shares back. More importantly, I'm sure this will please many of you, the FHC also has rights to unpaid dividends associated with those shares that are being returned. Now, it's important that I qualify before my next statement that this particular section has a number of different Russian statutes referenced, and I haven't read these, I don't have access to them, so what I'm about to say doesn't refer to any knowledge associated with these particular statutes. That said, what I see implied in this section is that as the suspension is in place, the ESO will declare dividends and it will pay to the Russian residents and the Russian citizens those dividends. But the dividends that would have been paid to foreign shareholders through the FSH will be held back as reserves. And when the suspension is over, basically the war is over, those dividends will be paid back to the FCH and they will be available for distribution to foreign shareholders like me and you. Now, it's important for me to say at this time that that particular express statement is not in this document. I'm seeing this as implied in the clause. And as I said before, the legislation itself is focused on and aimed at Russian businesses and Russian residents and Russian citizens. So I wouldn't expect it to be expressly stated, but it's certainly seen, in my opinion, in the intent of the document. Okay, moving on to Article 9. Article 9 is a lengthy section, and it basically covers the situation where a private ESO needs to become a public company within Russia. I'm not sure this relates to Evraz. I can't really work it out, to be honest with you. So if any of you have read this document, and especially this particular section, and have some insight into this, just add it to the comments. I'll be much appreciated. But I don't think it's that relevant to us as shareholders within companies like Evraz. Moving on to Article 10, therefore, Article 10 is quite complicated, and it took me quite a bit of time to read through this on a number of occasions before it really sunk in. That said, I think I've got the grasp of it now, and I think what it's saying that in certain conditions, when certain shareholders own shareholdings in the FCH, and the FCH cannot, because of the suspension or because of sanctions, pay dividends to those Russian shareholders, the ESO can actually pay out of its own profits those dividends in lieu of holding money back from the FCH when the war is over and the suspension is over. If my interpretation of this section is correct, and I think it is, then this section is less relevant to foreign shareholders like me and you. It's more relevant to large shareholders in the FHC or large Russian shareholders in the FHC and gives them a mechanism to get their dividends out while there are sanctions in place. That said, I do think there are some implications in this section that are important to foreign shareholders, and that again is that I think that it reaffirms that the ESO will be holding back money associated with dividend payments and therefore will be reimbursing foreign holding companies at some point in time after the war, after the suspension is lifted, so that it can pay shareholders like me and you. And of course, if that is the case, that's great. Finally, Articles 11 and 12 have really little relevance to foreign shareholders, and Article 13, the final article, just confirms that the legislation will be fully enacted on the 4th of September 2023. So what does all this mean? Well, to me at least, it's important first to remember that this legislation is drafted for Russian companies, Russian citizens, and Russian residents. So we should not expect too much express language about foreign shareholders and foreign companies. It does, however, expressly state that there is no intention through the legislation to unduly harm any foreign companies or foreign shareholders. And it also makes it clear that the Russian government think this legislation is temporary and that at some stage or other, probably when the war ends, a lot of this legislation will be lifted and some form of normality will be regained. That said, I would also guess that this legislation and any corporate rights that have been suspended will be used as bargaining chips when it comes down to lifting sanctions on Russia. Most importantly, however, and this was the crux of why I wanted to do this video, having read the legislation, is I don't see any reference or any real intention in this legislation that implies that Russia is in place or is planning to steal any of our shares. Moreover, I'm of a strong view that the ESO will hold back money that would have been given to the FHC for dividend payments to be shared out to foreign shareholders if the suspensions were not in place or the war didn't happen. And therefore, at the end of that suspension and war, these payments or this money will be returned to the FHC to be paid out as dividends to foreign shareholders whenever the foreign holding company is allowed to do that. That said, I must qualify this by saying this is how I read it, and of course I may be wrong, and even if I'm right, there's no reason why in the future the Russian government couldn't change the law and make it detrimental to foreign shareholders and foreign companies. I guess that is their prerogative if they want to do that. And it's for that reason that I would recommend that any of you who've not read this document itself, that you do read it and just at least get some peace of mind through your own understanding of it and use it as part of your own research. Okay, I do hope this video was useful. It's not something that I would normally have done. It's very different to what my normal videos are like, but I felt it was needed and it certainly helped me understand the position that I'm in. So if you did like the video, please give us a thumbs up and subscribe to the channel. But in the meantime, I'll see you in the next one. Bye-bye.